What's up, everybody? Welcome in to our post-Christmas episode here as we're all coming off the high of Christmas. I know it's a tough time for some, a beautiful time for others, but one thing continues on, and that is the world of true crime and these cases like Sarah Boone's, which we have a new-ish filing from about a week ago that a lot of you tagged me on Twitter asking me, what is this about James Owens saying Judge Kraynick made errors? And why does he want to look into some very specific potential errors made by Judge Kraynick and not others? We're going to read through that motion. We're going to watch even some clips of the parts that James Owen potentially takes issue with and talk about whether or not we think Judge Kraynick made some reversible errors throughout the entirety of Sarah Boone's case. So make sure you guys hit that like button. Make sure you're subscribed. Let's get into it. So this was filed about a week ago. I didn't even know it was filed. I haven't kept up with what's still going on in this case. But as I said, some of you guys tagged me here. I've got my my mountain beard going. I'm leaving for North Carolina tomorrow. I'm wearing one of my favorite Christmas presents, my Tally reversed hat here, which I know you guys will have some comments on. Why is it reversed? Why is it upside down? But here we are, nevertheless, continuing to cover Sarah Boone's case. And this document that was filed is a statement of judicial acts to be reviewed and motion for court reporter to transcribe the designated proceedings. Comes now the defendant appellant, and that's a little indication there. By and through undersigned counsel hereby issues the following statement of judicial acts to be reviewed. The court's denial of the defendant's motion for continuance on September 3rd, 2024. The court's denial of a second amended motion to suppress the defendant's statements at OCSO on October 2nd, 2024. The court's denial of the defendant's motion for new trial on December 2nd, 2024. Court's denial of defendant's motion for downward departure on December 2nd, 2024. The judgment and sentence of the court on December 2nd, 2024. In support of the aforementioned statement of judicial acts to be reviewed on appeal, the defendant/appellant hereby designates the following described proceedings to be transcribed by the circuit court reporter. The hearing on the motion for continuance held on September 3rd, 2024. Hearing on second amended motion to suppress defendant statements at OCSO held on October 2nd, 2024. Jury selection and trial held from October 14th, 2024 to October 25th, 2024. Sentencing held on December 2nd, 2024. In the certificate of service. And this was done by James Owens. So first off, people are asking, does this have to do with her appeal? And the answer is yes. Why is James Owen filing it? Maybe he's still working on it. Maybe it hasn't been passed off to appellate counsel yet. Maybe this was something that needed to be done prior to any deadlines and things that she needed before she had appellate counsel, before they could get up to date. Maybe appellate counsel is asking him what are the best parts or the most important parts for a potential appeal. Okay. All those are potential questions as to reasoning, but we don't really know why or if James Owens is going to stay on. I know he said he wasn't. If he changed his mind, that's his prerogative. So what is this document? Well, first, it is obviously pointing out certain sections that the defense thinks Judge Kraynick may have made mistakes or errors, and they want to review those to see if there are potential appellate issues. And if you see down here, the transcript and why they need this transcribed, she's indigent, so the state or JAC will pay for this transcription, but she needs everything transcribed that is not already in the court record, which is why you see certain hearings and the entire jury selection and trial, because that is not fully transcribed unless there is an appeal, unless it's asked for, unless it's paid for, which is what they're doing. And they need it transcribed because when you write an appeal, you cite the record. So you say on day 2 of trial, which is page 3046 in the transcript, the witness said X, Y, and Z. I objected and said this. The state responded with this. The judge made this ruling, and we think that's a reversible error. And this is what the case law says. And you put it all together and explain why. But you need that record cite because the appellate court is looking specifically when talking about errors during the trial to just what happened in that trial. And that's why we say if you don't make an objection, a lot of times you waive it. If you don't protect the record, a lot of times you waive those issues. So that's why you need the entire record printed out. But as we see, he mentioned the entire trial here and jury selection. But why certain specific motions? Well, first off, more could be transcribed later. depending on deadlines and if it's allowed, and, you know, assuming JAC approves the payment of all this stuff, he could still request more later. But why would he request these specific items? And I thought to help us out, it may be good to watch at least portions of these hearings. And if you notice here, the first is the court's denial of defendant's motion for continuance on September 3rd, 2024. So let's take a look at that. I'm going to bring that hearing up, which we did cover this hearing together. It wasn't the longest hearing in the world, but both sides made arguments. This was when James Owen just came on the case and he said, listen, Judge, I've got to file my notice of intent to rely on the battered spouse syndrome. I got to talk to experts. I've got so much I've got to do. So little time. I need a continuance. And the state's response was, Judge, we disagree. Sarah Boone has had this case forever. Lots of her lawyers have looked at battered spouse syndrome. They have had enough time, and Your Honor has already said no. But let's take a listen to the judge's decision and parse out why we think James Owens wants this transcribed.
Very much. All right, Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case. Yes. I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' bases for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel.
So that issue about waiver, constructive waiver of your right to court-appointed counsel, that issue is not what this hearing is about. So a lot of people are asking, why didn't we see that in the list? Why aren't they challenging Judge Kraynick's decision to force basically Sarah Boone, or say that Sarah Boone has constructively waived her right to counsel when she did not outright, with her own mouth, waive that right? Why isn't that on this list? Well, if you remember, and Judge Kraynick referenced it right here, he did a well thought out, well researched, and rather lengthy order setting out on the record in black and white exactly why he made that decision. So the fact that they didn't request it in this list does not mean it's an issue they're waiving or it's not going to be an appellate issue. I can almost guarantee you that is going to be one of their appellate issues. But they already have it in writing. They already have it on the record. They can already reference it, specifically page 2, line 16 of the judge's order, forcing the defendant to waive her right to counsel. I'm sure they'll use some kind of language like that. They already have that on the record. But this order, and many times when judges reduce their orders to writing, it can be different or less than what they say in court, which is why we're going to play out the next, 5 or 10 minutes of the judge's order, because what he says verbally and audibly is on the record and can be cited and can be argued if he made reversible error. So while we have the lengthy order on her constructive waiver of counsel in writing, the defense wants his verbal order in denying this motion for continuance so that they can reference it in their appeal. And I also believe this will absolutely be a major appellate issue for them. And we'll talk about the strength of these appellate issues a little later in the video.
Virtue of her actions. This case has been pending for some time. You advised in your motion to continue.
By the way, I'm going to back it up. These are the reasons he denies it right here.
This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in a judge portion that trial specially set for October 7th, 2024, and that it would not continue for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel.
You've been on this case a wee bit. Case has been around forever. The judge said it was her fault for a lot of the delays and a lot of the issues with the lawyers. You said you read my order, which said, absent just horrible, extraordinary circumstances. I'm not continuing this case. And guess what? Hiring a lawyer is not one of those extraordinary circumstances which I'm going to grant a continuance. And you still decided to take the case.
I've been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr.
And while he's taking notes and maybe even writing down as much as he can of what the judge is saying, that doesn't count. You can't say, I'm referencing my notes, page 1 from this hearing. That doesn't work. You got to get the actual transcript.
Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert. And as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State, 221 Southern 3rd 562 at 569, there's a 2-part test.
By the way, a lot of times judges will write out a lot of what they say because once they read it onto the record, they don't need to do as detailed of an order. Sometimes they still do. Sometimes they enter what they read right into the record. Sometimes they ad lib. Sometimes they add to it, which is why you need the record. And that's why a lot of this is done. And a lot of it is requested because lawyers have to read, listen, write, do all sorts of different things every time they file a motion, handle an appeal. And he is specifically citing the case law, putting the cites in for this specific purpose so the record is correct.
Determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, at pinpoint 1281.
And if you can tell, he's looking at his computer screen, he's looking down at a piece of paper, he's looking at them for part of it, so he's not reading something. So this is going to be different than whatever he had down on paper, even if he did file a written order.
By the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice.
Her right to be adequately prepared for trial is counterbalanced by the fair administration of justice. Interesting line there. I listened closer the second time than when we watched it together, and that's an interesting line.
As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out to deal.
By the way, you see how he says 4, not 7, 8, 9, all the different attorneys, because he's not trying to beef it up. He's not trying to be hyperbolic. He's saying these are the 4 that didn't have any conflicts, that could actually be her lawyer, and she messed it up with all 4, basically.
Banquets, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based
only has herself to blame for the withdrawal of those 4 attorneys.
On the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings.
And that's also why she kept saying, nobody reviewed it with me, nobody reviewed it with me, nobody reviewed it with me. And you know what's interesting? This just popped into my head. I don't really know the answer because I've never dealt with a case where a defendant has handwritten letters and put them into the record. Are they going to be able to say Miss Boone's letter on this date, page 3, where she says Miss Cashman did not review the discovery with her, is in contradiction to the judge's order and factual finding on this day? Be tough, but the judge read those letters too and still made that factual finding. So he analyzed the evidence before him and still made the decision when it was his decision to make.
The prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had the discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you were not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311 sub 3rd 185 pinpoint 189, Florida 2nd DCA 2020, your motion for continuance is denied. Matter of this trial.
So it's denied for all those reasons. So what do we think? Is that going to be an appellate issue? Yes, it's going to be an appellate issue. Is it going to be a successful one? Because a lot of people reminded me that I said I would have given a short continuance. Just because I would have given a short continuance and Judge Kraynick did not, doesn't mean that I even believe it's going to be an appellate issue that's going to be successful for Sarah Boone, because that's almost the definition of discretion, right? It's like, I would have, I don't think you have to. Kraynick didn't. Again, I don't think he has to. I think the warning he put in his order, the fact that Owens said he read the order before taking the job, and again, all the reasons he listed in the case law. Now that one statement about, counterbalancing her right to a fair trial with the administration of justice, to me, he's reading that straight out of the case law. And I think he is a well-read, well-researched judge. And when something is within his discretion, such as that, I do not think that is going to be an appellate issue. I really don't. Now, the best appellate issue, or I should say the most novel appellate issue I think that she is going to have is Judge Kraynick's finding that she waived her right to counsel, a constructive waiver. That is something I've never really dealt with. I haven't seen a lot of it in the appellate court. So that's the one I just don't know the answer to, that if I was her appellate attorney, I would spend most of my time on that, trying to convince the higher court that that was inappropriate. That then pushed her into this request for a continuance, and he could have cured that problem and he didn't. And this was a pile-on effect kind of thing. That I think is going to be her best appellate argument. Will it be successful? I really don't know, because I haven't seen enough of those go through the pipe. Now let's take a look at the October 3rd, I think it was, October 2nd hearing. And this was the hearing where they were trying to suppress her statements that she made in the interrogation. They went through the fact the cops lied to her. to get her down there. She wasn't read Miranda appropriately on the card. There were arguments both ways. They also made some other arguments during this motion hearing, but this is the court's very short order after all of the testimony and arguments were made.
Further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, and for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving.
That's it. That's all he said. And then he prepared a written order. So why order this transcript? Well, many times lawyers draft motions. They make arguments in those motions. They put case law in those motions. We're not going to watch this 2.5-hour hearing again, but you remember we watched this together. This was the hearing that they made a bunch of arguments at, but that they also had Detective Copsell on the stand testifying. And guess what? This is not reduced to writing unless you request it. But guess who else testified at this hearing? If you remember, this was the day Sarah Boone herself took the stand. So Sarah Boone took the stand, and they want to use, most likely, they want to use some of what she said in this hearing on the stand, get it transcribed, and use it in their argument. It is on the record. It is record evidence. And again, they can go to the judge's written order and, argue about what the judge put in his order, anything he said, any of his research, any of the statements that he made. But in order to use what Sarah Boone said, what Detective Copsell said, the arguments made by the lawyers potentially, and why Judge Kraynick was wrong, if that's what they want to argue, you have to reduce it to writing, which again is the point and purpose of this document that we read through together today. So that was the question that I got on Twitter, on social media. Hopefully that answered your questions. If you guys have more questions, feel free to throw them at me. I appreciate it. I don't know if content's going to be busy or slow during this next week while I'm up in North Carolina, but when stuff pops, when you guys have questions, if I'm able to, I'm just going to pop on. I'm going to jump on. I'm going to do a live. Some of them might not be well planned out. So make sure you guys are all subscribed and you hit that reminder bell. Also, it's just content has been funny near the end of the year, and people jump on so many little details. And I think at the beginning of the last video, when we were talking about Luigi Mangione, and I said that his lawyer had some nasty comments for the mayor. People are like, I can't believe you called her nasty. First off, I didn't call her nasty. I said she had some nasty comments, and I stand by that. I think she did. And by the way, just because I call somebody's comments nasty doesn't mean I don't like them. Doesn't mean I don't agree with them, or at least some of them that she made. And it definitely doesn't think I think that she's not a good lawyer. The video before, we're drooling over her resume basically and saying what a great resume she has. So, people read into certain things. It's an evidence of once people jump on a certain side of a case or jump on a certain narrative, and a lot of people jumping on the side of Luigi Mangione in that case, they will find any reason to fight with somebody about it, even somebody that's not fighting with them. So I just thought that was interesting. So keep your heads held high at the end of this year. Keep giving people grace, and let's get better every single year, not just January 1. We can start today. So I appreciate you guys so much. That's all I got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.